हेलो ऑल। वेलकम टू कॉर्पोरेट लॉ जर्नल चैनल। हमने एक नई वेब सीरीज लॉन्च की थी नेगोशिएबल इंस्ट्रूमेंट्स एक्ट 1881 पे। वी वेलकम यू टू एपिसोड नंबर 1 in which we will discuss objective of the NI Act, scope of the NI Act, and validity of checks as a concept within NI Act. Coming to objective and purpose of the NI Act. NI Act के तीन main objectives and purposes हैं. Number 1, regulating growing businesses, trade, commerce, and industrial activities within the country. Number 2, promoting greater vigilance in financial matters. And number 3, to safeguard the faith of creditors in drawer of the check. The NI Act protects the rights of the parties when they discharge their obligations diligently. ये एक्ट एक ऐसा एक्ट है जिसमें penal provisions यानी punishments भी हैं for any violations or offences under the act. The act eliminates all kinds of discrepancies of hurdles that may arise between the parties. The act provides for penal provisions for effective implementation of the NI Act, negotiable instruments process among the parties. अब हम आते हैं NI Act की salient features पे. इस एक्ट के कुछ salient features हैं which make this act what it is. Firstly, every negotiable instrument transaction is in writing and can serve as a prima facie document or evidence in a court of law. इसका ये मतलब है कि कोई भी negotiable instrument act orally नहीं carry out किया जा सकता है. It is always going to be in writing, and since it is in writing, since it is in a tangible form, इसको एक evidence and as document it can be used in a court of law अगर कोई dispute arise होती भी है between the two parties. Second salient feature, signature acts as an authentication of the valid consent for the settlement transactions between the parties. कॉन्ट्रैक्ट कमर्शियल कंपनी लॉ का एक बहुत बड़ा एस्पेक्ट कंसेंट होता है. सिग्नेचर acts as an authentication of valid consent, meaning when the two parties agree to take part in a contract where a negotiable instrument is involved, जो सिग्नेचर होता है it acts as a valid document, it acts as witness and or as evidence of that valid consent. Third, the transactions in legal money would be the intention to have under negotiable instruments. Any other transaction would be invalid. यानी कि लीगल टेंडर मनी के अलावा कोई और ट्रांजैक्शन वैलिड नहीं है for under negotiable instruments. Fourth salient feature is that this is a safe and convenient mode of payment and settlement between the parties. There is no need for any cash. The convenient mode of transaction and the efficient mode of the system both are simultaneously required for development and growth. This is the fifth salient feature of the NI Act. Coming to scope of the Negotiable Instruments Act. Section 138 of the Negotiable Instruments Act is on dishonor of checks. It reflects the anxiety of the legislature to usher in a new healthy commercial morality through the instrumentality of the penal law. What was, prior to the amendment of the Negotiable Instruments Act in 1988, only a morally or a civil wrong has been transformed and exalted to the position of a crime by a deft amendment of the statute. This basically means that Section 138 is the reason why Negotiable Instruments Act can be called a penal statute. It introduced a penalty or imprisonment term or a specific amount of fine in compensation to violation of Section 138 of the Negotiable Instruments Act or dishonor of check. There are essential requirements that need to be fulfilled in order for an act to come under Section 138 of the NI Act. These requirements are: the check for an amount is issued by the drawer to the payee or the complainant on a bank account maintained by him. The said check is issued for the discharge in whole or in part of any debt or other liability. The check is returned by the bank unpaid on account of insufficient amount to honor the check, or it exceeds the amount arranged to be paid from that account by an agreement made with the bank. The check is presented within 6 and now, with the amendment, 3 months from the date on which it is drawn or within the period of its validity. 30 days demand notice is issued by the payee or the holder in due course on receipt of information by him from the bank regarding the dishonor of the check. The drawer of said check fails to make payment of the said amount of the money to the payee or the holder or the complainant on due course within 15 days of the said notice. The debt or liability against which the check was issued is legally enforceable. अब हम आते हैं सेक्शन 138 ऑफ द एनआई एक्ट एंड इट्स इंपॉर्टेंट इंग्रेडिएंट्स पे. हमने पिछली स्लाइड में जो एसेंशियल रिक्वायरमेंट्स देखे थे अंडर सेक्शन 138, उसको हम इस स्लाइड में थोड़े सिंप्लीफाइड मैनर में बताएंगे. Section 138 of the NI Act deals with the procedure, trial, cognizance, defense, and punishment relating to dishonor of checks. It is not by itself an offense under Section 138, but it has to fulfill the following elements. Firstly, drawing of the check. The check, which is a negotiable instrument under Negotiable Instruments Act, has to be drawn for there to be a dispute that comes under Negotiable Instruments Act. Secondly, presentation of check to the banks. The check has to be presented to the bank for encashment. Third, drawee bank returns unpaid check. Because Section 138 talks about dishonor of checks, the drawee bank has to return the check unpaid on account of lack of balance or an agreement between the bank and the drawer that a check is returning unpaid, and the bank has to return the same. Fourth, giving notice in writing to the drawer. And fifth, the failure of the drawer to make a payment within 15 days. According to the NI Act, within 15 days from the receipt of the notice by the drawer has the timeline of 15 days to make the payment. We will delve into the concept of validity of checks even further in the coming episodes. But for now, we have written two cases which established the scope of legislature under Section 138. In the case Anil Vasudev Rajgor versus State of Gujarat in 2017, it was held that the provisions of Section 138 were enacted, taking into consideration the currency of checks for 6 months from the date of the issue, which basically means that the Negotiable Instruments Act contemplates checks with validity less than 6 months and stipulates that checks should be presented for encashment within the expiry of that period. In the case of Nandeshwari Steel Limited versus State of Gujarat, it was held that checks issued before determination of debt, that is, before there has been adjudication on the matter of whether debt from the check is obtained or not, if the check is presented or issued before the determination of this debt, the complaint will not be held to be maintainable. Thank you so much for watching episode 1. Please like, comment your thoughts, and subscribe to Corporate Law Journal to be updated with further episodes in the Negotiable Instrument Act's web series. Thank you.